Ideas. It seems like that's all we run on in America. When it comes to making things right, all we need is a great idea. We vaunt the idea people, creative minds so fertile that their ideas have ideas, and each one promises to improve our dull realities. Trouble is, an idea is just a thought. There's no action, no framework, no ignition switch. It's all gas, no engine. On top of that, if the idea is really combustible, the trouble's just beginning. Once you decide to do something with an idea, make a product or solve a problem in a repeatable way, do you file first? Do you patent it? Use a digital rights management system? Do you write it on a piece of paper and mail it to yourself and then swallow it? Even further, all the drafting work, early proof of concept stuff on your browser at home, emails, messages to designers and angel investors, is all that secure? According to CNN, theft of American intellectual property currently costs the country almost $600 billion annually. Now, with more and more business happening online and more devices connected to wider global networks, do we have any idea what the future of ideas and IP law looks like? That's what we're talking about today on Lawsome. Who's down with O.P.I.P? Let's dig in.
Lawsome, the podcast for law firms. Powered by ConsultWebs.
Welcome back to Lawsome, the only podcast for law firms that never fills you up, but never lets you down the rabbit hole of if we're stealing other people's taglines or not. Or maybe it's Maybelline. We're here to inform, educate, and entertain the legal community on the latest in personal and professional developments. I am Jake Sanders, the Cyrano de Bergerac to the much more handsome Paul Julius. Paul, remember when we ordered Carl's Jr. and I ordered in your voice? And when we paid, they thought it was you that ordered?
Oh, that was so crazy. And we just kept playing it back and forth. Like it was who really said that, you know? And then they were just like, sir, this is the drive-thru. We can see you.
I know.
And then
we're like, we can see you.
Yeah, totally.
Threw it back and I said it in your voice.
Well, yeah. And then at the end, it was just like, but whose name's on that debit card? And they were like, John Smith. And we were like, that's right. We stole it.
Theft. And we admitted to it here on the podcast again.
It was great. Yeah, it's just Carl's Jr. It's just petty theft. No big deal. John, we thank you for those burgers, man.
Thank you, Mr. John Smith.
Yep.
Brought to you today by Carl's Jr.
And LifeLock.
All right. What's on the show today?
Today, we discuss intellectual property law and the Internet of Things with articles from Lexology, Forbes, and the Legal Intelligencer. And then we interview CEO of TurboPatent Corp, Jim Billmaier, to learn what the future of ideas and IP law look like in America. And as always, we put our guest on the hot seat with 5 questions we ask everyone.
Pull up a plate. It's the Hot Takes Buffet.
The articles today are from a variety of places. Law.com, the Legal Intelligencer, Forbes, Lexology. We'll start with the first one. It was entitled, Can the Law Keep Up with the Internet of Things? By Jeffrey Rosenthal and Thomas Breyer Jr. The answer's no to that one. Right, Paul?
I mean, people can't keep up with the Internet of Things. I'm not surprised that the law can't either.
Good point.
Yeah. I mean, to try and put this into something a little bit more easily understandable. Some people have stuff where their fridge and their washer dryer, all that stuff is hooked up to their internet and they can control it through Alexa. But one of the examples they bring up here is baby monitor on Wi-Fi. These ISP offered home security systems. What if somebody hacks into that? What if somebody hacks into your Wi-Fi and can look into your baby monitors, or taps into the garage cam,
or your Nest, or your smart storytelling teddy bear? Teddy Ruxpin's back all of a sudden with Wi-Fi and Bluetooth.
So who's liable for that? I mean, and what happens with it once it's stolen?
In this article, they talk about what regulatory frameworks exist in regards to the Internet of Things, IoT. And so in September of 2018, California was the first only state, to do something about the Internet of Things. Federal trade commissions behind it. Violation of any of these laws is not privately enforceable. Like no lawyer could take it. Only the state's attorney general could bring a claim. But all of the exemptions and limitations on the manufacturers, third-party people, all of these things, it makes it so kind of toothless that it doesn't quite make sense. So in the article of the Legal Intelligencer, Jeffrey Rosenthal and Thomas Breyer are talking about that there is a lack of regulatory frameworks keeping up with the proliferation of, intellectual property, inventions, the Internet of Things. All of that stuff is kind of inherently connected. So that was the takeaway from this, is that no, the law can't keep up.
A lot of what we're talking about in this article and what they're talking about in this article is security. And it says that what California is saying is that they're requiring manufacturers to equip these devices with, quote, reasonable security. Because right now, there's nothing there that says anything about it. You get hacked, too bad. Should have a stronger password. Not our fault.
Yep. So, but as of January 1st, 2020, California is putting this in to make sure that those manufacturers do at least exercise some of that caution. And if they don't, then there is a framework for something to take place, but that's only one state. But you brought up a really good point. And that's what my hot take is about all of this. Lexology is the piece from Lexology broke out the law itself. And the piece from Forbes is 10 effective ways to protect your intellectual property. It all is dependent upon security. It's like, don't file patents, but then they say file it everywhere. Open source it. But who can you trust with any of that? Avoid joint ownership. Some people don't have any other way that they can do it. So really, we discover later with Jim that it still is a place. What did he say? It's a game of kings. Mm-hmm. If you have resources and you have the wherewithal to control the information, to understand it, then you can do it. But if you don't, and a lot of lawyers are sitting around wondering, where is their career going? Intellectual property lawyers, where is this headed? Where is product liability law happening? Where is data privacy? What is data privacy anymore when Teddy Ruxpin's, sneaking up on me? I think law firms need to take it seriously because it's about the privacy of their clients' information, their staff, all of the stuff with third-party vendors. So privacy, data security, keeping everything on lock in the future is going to be more complicated, but at least people are aware of it. And there's companies and corporations that are helping people control that. But yet, doing research, $600 billion is lost annually to intellectual property, theft, stealing movies, ideas, trade secrets. I mean, you name it. The designs of a wind turbine snuck out somewhere from Massachusetts. Who's there? And what regulatory frameworks do I have if I feel like that was wrong? Am I, do I have a claim? Is there a claim?
Right. And I think too, some of this stuff, just to make sure we're clear that, with these, when we're talking about, ways to protect your intellectual property, we're not necessarily talking about in the law firm, your particular documents and stuff like that. Like that's a different kind of security. But
still,
we're talking about,
it's related.
Right. But we're talking about in a larger sense of this IP patent law, these processes, these things are going to start to be looked at in a different way. Once California's law takes effect, once people start to look at these things and say, wait a minute, filing these patents, these processes, these different things have a certain manufacturer's requirement built in that these patents are going to need to meet. To me, my hot take on all these different articles was that in some sense, the future mass torts may not be against a medical device company, but it may be against a home security company, or you may be looking at more data breaches, or a defective product where someone's didn't meet the minimum required thing as mandated by the state. In this one Forbes article, there's a couple different things in here that really stuck out to me, like separate teams and avoid joint ownership when you're talking about actual intellectual property. These are things that I could see in the future law firms getting involved with to make sure that consumers are protected, that inventors are protected, that companies are protected. So there's a whole new kind of realm within the Internet of Things and these different, software and new smart technology patents that it barely exists now, and it didn't exist 10 years ago, that people are going to need to be aware of.
Well, and I would say that it is going from nascent to firm and concrete within months, years. So, Jim has been in the game, software game, figuring out intellectual property since 1995, working with Sun Microsystems all the way up until now, taking a comprehensive, holistic look at the way we handle ideas. And that really is the engine of capital and business. And any small business, especially a law firm, runs on those ideas. And so how do we make them real? How do we, make them a part of our portfolios and, strengthen our communities and our countries and our companies with our ideas? And, if lawyers can be there with augmented intelligence, is one of the things Jim talks about, is it's not replacing lawyers. It's just helping them make better decisions, and they need to be there. But if you're not there, then you're on the sideline. And he has a phrase, and he says, in the future, you can either eat lunch or be lunch. So,
yeah, right now, these things maybe not as commonplace outside of Silicon Valley. Particularly some of these different contract and patent things that Jim specifically gets into. But what's fascinating is that what happens in that maybe smaller, more niche community is going to have ripple effects everywhere else as these processes that they streamline, they automate, they augment with computerized intelligence become more commonplace, and lawyers can handle larger, more complicated matters, or communicate bigger settlements and terms and conditions.
Good point.
These things are going to trickle down. I hate to say trickle down, but I mean, it does fit here that it's going to go to any product that has some sort of user agreement. Anything like that is going to feel this, because these are the innovators, and this is where stuff is going to be spread from. And these guys aren't investing their money in there just because they love lawyers. I mean, they're doing this because there's profit to be made, and they see an opportunity. It's pretty eye-opening, I think, for people to understand just how far down the road this is gone, because it's going to be hitting everywhere sooner than you think.
And now, a word from our sponsor.
Since 1999, ConsultWebs has been helping law firms connect with clients on the web, connect digital marketing success with firm success, and connect their business goals to proven strategies that help them get the most out of their legal marketing. Go to consultwebs.com to learn more.
And now, for a lawsome interview.
Jim Billmaier is the CEO and co-founder of TurboPatent Corporation, the creators of the TurboPatent Automated Invention Protection Solution, and is the author and originator of the concepts contained in the book Inventioneering, which outlines the smartest CEOs will fuse engineering and invention to dominate the next decade. In 2005, he founded Patent Navigation, Inc., an IP strategy consultant company. Jim has also served as chairman and CEO of several companies, including Asymmetrics, Digio, and Melodio, Inc., a cloud-based media platform company acquired by the Hewlett-Packard Corporation in 2010. And as if all that wasn't enough, Jim has decided to pad his resume with an appearance on the Lawson podcast. Jim, thanks for coming aboard.
Oh, my pleasure. Thanks for having me.
So you've been at the helm of numerous successful tech ventures. Can you give us the story of what led you here and why you're now focused on invention protection as well as legal tech?
Yeah, well, it actually is very connected to those efforts as an entrepreneur in previous companies. In 1995, sorry to go back so far, I was vice president general manager of Sun Microsystems networking group, where we did Java and some other things like
Huge.
that. But the other thing that sort of changed my life is I think I was absent for the meeting where the CEO said, "Hey, we need somebody to figure out what this software patent stuff means, because software wasn't patentable prior to that. And so I was the one-eyed man in the land of the blind, I guess. So I kind of got into it there a little bit. And then when I joined Paul Allen up in 1995 up here in Washington, sort of the same thing happened. And he had a research organization that I was vice chairman of called Interval Research down in Palo Alto. We did the Digio Corporation, which did 400 patents in a couple of years, which is a lot for a startup company. And as a result, I built a little boutique patent group inside the company, and also had several folks outside the company who were helping to keep up with that quantity of invention and patenting. And as a result, I met the co-founder of TurboPatent, a gentleman named Charles Mirho, who is a patent attorney, used to be a software guy. And just observing, how software was built and compare it to how patents were built, it was, oh my gosh, you guys may as well be using typewriters. What is going on here? And it turned out, at least in that day, there was very little motivation for any improvement from a technological standpoint, because all it did was reduce billable hours, right? And so, I kind of tucked that away in my head. We did some other companies, Melodio that you mentioned, did patents there. And then after we sold, this was 2005, 2010, after we sold that company, I talked to Charles a bit, and just the aha moment was that, patents look a lot like a piece of software, and yet the tool chain for building software is very, very sophisticated, very powerful, results in, being able to build a lot of stuff very quickly and high quality. And none of that, the state of the art in the patent world is Word and Visio. And so everything is sort of a bespoke process. And it was then we said, hey, we think we could really make an impact here by, really bringing some of that same kind of technology to the legal world. And that was 6 years ago when we founded the TurboPatent Corporation. So that's kind of how I got here. I'm not a patent attorney. I am an inventor. I have about 100 plus patents that I've invented, either as the lead.
That's amazing.
But just had to watch the painful, expensive process for the last 20.
So just right off the bat, the fact that billable hours was a protected kind of thing, we need to go through all this stuff. So if you automate that process, you take away those billable hours. Is that kind of essentially what you're saying? That's sort of the frustration there, or can you get into that?
Yeah, here's what happened, because we actually kind of test marketed it in like the 2006 timeframe to see, hey, if we went and did this, and we had a lot of, obviously I'd met a lot of patent attorneys, and they gave us that answer. It's like, oh, the firm's never going to do that. That's going to just reduce our billable hours, but we've always done it this way, so on and so forth. But there was a change that happened leading up to 2008, the Great Recession, is that corporations started putting a hammer down, and more of the large corporations started saying no more billable hours for at least the production, the preparation, prosecution of patents. They said, we're going to fixed fee. So you got companies like Microsoft, Amazon, Google, these kind of big companies. They don't pay billable hours. In fact, they pay compressed fixed fee. So now there's a more of a motivation to be able to make high quality patents, but do it in less time. So we are seeing that was sort of what we viewed as kind of a change point. Now I suggest at least in the technology space, probably 65%, maybe even more of patents are billed on a fixed fee as opposed to just let the clock run. So that has been a change that really has made the market more appropriate for us at this point.
Just to keep wandering down this path for a second, we've had several guests on the show who are looking at the procurement side of things. I'm curious your thoughts on that, where there's this relationship that's being developed between legal and procurement, where people are looking more for that the same way that they would look at like a supply chain. And I'm just kind of curious what you think about that, particularly talking about flat fees or a service-based fee as opposed to this hourly rate.
Yeah, I do see a trend where, let's go back 10 years. it was unheard of to have a purchasing person involved in the quote unquote buying process of doing legal work, right?
Mm.
And yet, so the standard method was, well, I worked with this guy at the firm I worked at before I came here. So it was a very relationship, I might almost say incestuous kind of decision process. And then what I see now is professional purchasing people coming in and saying, no, we're gonna run a process. We're going to make certain that they're using things that make them efficient. We're going to, kind of clamp down on some of these costs, et cetera. And I see that kind of happening broadly in legal, where corporations are trying to consolidate, trying to make certain that their suppliers are doing things that are more efficient, et cetera. And that's happened in a lot of different industries, and now it's just catching up to legal.
Mm. God, that's so amazing. So, talking about what a fascinating time to be involved with ideas and IP law. So there's tons of technology being developed, like daily, hourly. IP law is one of the hottest practice areas out there, specifically regarding the patent process. What have you identified as problematic? Has it always been problematic, or is technology outpacing the processes here?
Well, several things that I observe. I'm not sure that the technology certainly isn't being absorbed at a pace that outpaces the process. If there's anything, it's the reverse. That there's more sort of inertia to law firms, et cetera, embracing this, and we can talk about the views on that. A lot of that's covered in the book Engineering.
Yes.
But what I see is that the patent world has long suffered from basically building everything from scratch. I mean, they sometimes use templates and this kind of thing, but the tools that they have to actually make themselves more efficient just really haven't been there for a variety of reasons. One is it's hard to sell to legal tech. And another problem that I see is that a lot of the innovation is coming from small companies, and the current patent process in the United States, probably worldwide, is not very democratic. The big companies don't need to worry about them. I mean, Microsoft spends literally hundreds of millions of dollars a year building patent portfolio, but little companies can't afford to do that.
Mm-hmm.
So it's become a little bit of a game of kings. And we think that it's kind of dereliction of duty, even as small companies. If you're building all this great intellectual property, but you're not protecting it, and so we sort of see a parallel path. That you have the product path, and then there just needs to be a parallel path that goes along with that is protecting your inventions, et cetera. And it doesn't have to be patents; it could be trade secrets, it could be other things that you can do. But it's unfortunately not very well understood by the smaller entrepreneurs, and certainly in most cases the cost is prohibitive for them to really embrace it.
You created TurboPatent with the goal of using technology to automate and improve this antiquated patenting process that you kind of unpacked here. Can you point out some key areas or processes you targeted with TurboPatent, and how you guys are kind of changing the game here, changing that game of kings,
Yeah. So what we observed is that, again, if I go back to our analogy, because I'm a software guy, so everything's like a piece of software.
Love it.
So, software developers are you familiar with GitHub, right?
Yes.
So software development has become more of an effort of assembling components and then maybe, writing some code around them and whatnot to make them the features and functions that you want, whether it be open source or other kinds of licensed technology. So one of the things that we created is a thing called Patent Hub, and it's effectively GitHub for patent content. So drawings, definitions, boilerplate, all of this stuff, but it's not just static. It's like GitHub, where when you put it together in our tool, it does all the right things. It puts it all in the right places. It numbers it correctly. The other big thing that we saw is that there were so many errors if you look at the current millions of patents that are out there, the amount of errors and whatnot that are in existing granted patents that make them weaker is astounding. I mean, it's a significant, well over 50%. And that's because it's really hard to write, a 50-page document and make certain that everything is connected. But the way we like to think of it is it's really hard to do that without tools because you effectively are putting bugs in it. So we have a debugger in our system that has all of the rules, the patent legal rules, built into an AI system so that when you're writing the patent, it will warn you, no, that's an antecedent-based problem, or that claim is not supported in your specification. And it will, in real time, warn you of that. The other thing that drove me crazy is that if you had this 50 or 100-page document and you made one change somewhere, that change could ripple through in 50 to 100 to 200 places in the document. And you effectively, as a human being, had to go through and find each of those places and update the number or the word or whatever it was. And that's just not something humans are good at. That's something machines are really good at. So we built an editor that basically you make a change in a drawing, it ripples through the entire document. So you don't have to worry about that anymore. A lot of these are tedious tasks. We also have things where the machine itself will write a lot of the text for you. It will actually, from a claim, a textual claim, make a flowchart or a system diagram if you command it to do so. So I don't like to view it as artificial intelligence. I kind of view it as augmented intelligence because it's not like you're completely removing the attorney. You still need that brain power to interpret things and to kind of control the system. But boy, can you do a lot better than just Word and Visio that don't know anything about patents and don't know anything about each other. So that's kind of the tact and the approach that we've taken.
Very cool.
That's an awful lot of relying on Control F. You know what I mean? Like, it sounds like, that's just not something that people can kind of handle. But I'm curious, looking back at it onto the, I guess I imagine, one person toiling away under a light, up at night, reading through these documents. I mean, it sounds to me like what you got going on here is allowing lawyers and law firms to really focus in on some of the more, I don't want to say personal, but some of the more, the stuff that you need people looking at, as opposed to going through and looking for 200 and something places where something needs to be changed to a plural version of a word or something like that. You know what I mean?
That's exactly right. And there's a lot of other things, but I would say if you look at a patent, and we kind of dissected patents, so somewhere between 25 and 32 hours of patent attorney time, which could run anywhere from $250 to $1,000 an hour. So it can be a very, very expensive process. And right now, we believe we've taken probably about 50 to 60% of the time out of that. And most of that is not what you would call quote unquote legal work. It's as you guys know, it's what machines can do. But it's what current lawyers are expected to do to complete the document because there's no other automatic or technical assistance for them. So, it's there's a lot of room in certainly patent documents and patent prosecution that do not require, the brain of a lawyer. And a lot of that's already happening. I mean, a lot of them are outsourcing to paralegal. There's been outsourcing to what we call patent engineers, people who are not attorneys, somewhat lower paid, but still have the technical capability of writing up a lot of this. Because at the end of the day, a patent is probably a lot more of a technical document than it is a legal document, but it needs to be written in a way that, is legalese. So, I think that ultimately we can get probably this down to sub 10 hours, maybe even sub 5 hours of actual patent attorney time required, but down from 30, 40 hours.
We're really big proponents of outsourcing and automating, provided it makes sense. And I think we've kind of talked about some ways here where it does make sense. And you've obviously embraced that with TurboPatent as well, by providing these softwares and services that are going to help these patent practitioners increase their output. I mean, like you just said, the slash in man hours spent is unreal. But something we've encountered too is people have a hard time kind of getting their foot in the water. So Do you have any tips for lawyers or law firms who want to start taking advantage of some of these opportunities but aren't really sure where to start?
Yeah, and one of the things we have observed is there is that inertia, that resistance in law firms, and I can tell you my observation is why. It's a conservative organization to start with. Law firms, unlike corporations, are not really organized to make centralized decisions that can be broadly applied. So it's very difficult for lots of reasons for these firms to move over. So one of the things that we've done is we built our own set of patent practitioners that are well trained on these tools, and we're actually just outsourcing for law firms where we're behind the scenes writing the patents for them. We call it ghost writing, where they're still controlling the customer and having those relationships, but so that they don't have to become trained and whatnot. This is a way for them to sort of ease in this kind of technology and try it out in their law firms without having to train people, because it's if you've been doing something for so long in one way, it is a change to try to use these tools. And what we found is it usually takes a couple of matters, probably 2 patents or more, to get to the point as an attorney where you're now comfortable with this technology. And for a lot of them, they just can't the term I use is I can't stop for gas now, I'm already late kind of mentality. Right. So we do see that resistance. And so what we've done is kind of built our own set of people who can operate these tools and create the applications without people having to spend the time to come up to speed on it.
In the intro, I kind of discussed last year, $600 billion is lost in IP theft from America, and it's being leached out, and we're not sure where or how or what. In regards to law firms being hesitant and being resistant to change because they're conservative and not organized to make centralized decisions that can be broadly applied, which I appreciate that definition. Security risk. How do you manage that? And what are you seeing going forward as far as like maintaining the sanctity and holding those places safe, like idea conservation green zones, or places like national parks for ideas? Is there places where these ideas can roam and be free, or are they always in danger of being poached? That's a big metaphor, but do you see where I'm headed?
Yeah, I think so to a certain extent. Of course, there's a huge movement in the software world and some other worlds as well for open source kinds of things that allow it to be unprotected, and that's not how you're going to try to create your advantage in the marketplace.
Right.
But a lot of times, a lot of money is spent creating these things, and then to just have them quickly copied, by copycats, whether it be in the United States or China or whatever.
Yeah.
Doesn't feel real good. Security in general was a huge issue when we first started the company. The whole idea of holding things in the cloud and all of this was, it just scared the heck out of law firms and other people. I think now it's been effectively proven that the 3,000 security experts at Amazon are going to do a way better job of protecting your data than trying to keep it in a law firm with 2 IT guys who, don't really have the resources and whatnot. And we've seen the Chinese and others attack law firms because there is a lot of valuable information sitting in law firms. And quite frankly, law firms are one of the least capable of protecting that information when it's sitting in their own site. But that has been an issue. I see the Chinese, by the way, just fully embracing the patent system. They are now out patenting and really using the patent system as a way to create competitive advantage, which I think surprises a lot of people. Most people think, the Chinese just steal things. Not true. They're doing a lot of original inventing, and they're patenting the heck out of it.
Oh, yeah. Its ideas are sort of like a crude oil of, the future. Data is that. It is that king-making material, and if you can control it and understand it, and the regulations and frameworks they're set up around regulating and keeping these things safe and within the national domain, or opening them up and making the world a better place. I mean, you're sitting on those thoughts. And I just, doing the research, I was blown away. I was like, man, this is so cool. So in regard to inventioneering, just on a local law firm, some of our people aren't IP lawyers. Some of our audience, they're just your average JD on the street. What is something that you would tell just a lawyer just walking through a legal seminar hallway about IP law and what maybe they can be looking for in regards to that legal procurement mindset that people have taken the axes to their budgets in 2008, trying to figure out, we got to be lean, we got to be, resourceful. What's some of your advice to just the JD on the street, the lawyer that's sitting on the sidelines of the peanut gallery watching this conversation?
Yeah, I think IP is not the only space, as you guys know, that's has a lot of innovation and technology being applied to it. And I think we're at the early stages of it, but a lot of it is ready for use now. And I guess the advice, my CEO at Sun, a guy named Scott McNeely, used to say, "Hey, you can either eat lunch or be lunch." And what I think I would tell them is, you can either eat lunch or be lunch. You want to be on the right side of history. You need to embrace and really spend part of your hours looking at how to make yourself more efficient, more effective, because it is going. I mean, if we can drop from 35 hours to 5 hours, the amount of legal time required to make a patent, that's just one, aspect of law. This can be done. I've seen it with non-disclosures. I've seen it use a document review, and it's just going to get bigger, better, faster. And so I think there's going to be the people who embrace this and really get out in front are going to do really well, and those that lag behind are probably going to be lunch.
Ain't that the truth? So we just, last question real quick, zooming out of the IP patent area to legal tech in general. How do you think technology is changing in the legal industry? Recently, the Yale Journal of Law and Technology had a piece called Lola versus Skadden and the automation of the legal profession. And it was funny because a lawyer was complaining that they weren't getting their social capital out of their job because they were a glorified robot lawyer, going through things that a lawyer like a robot had already done. Do you see the future in regards to those JDs on the streets? Do you see them maybe getting kicked out of the billable hour? Should they be thinking of fixed fees or just kind of legal tech in general? What do you see on the horizon?
Yeah, I mean, just in general, AI and robotics and, all those kinds of things. We have bots that do things that senior patent attorneys used to do in reviewing documents. We were very pleased with the Lola decision. For your listeners, it basically says that, hey, if a machine can solely do it, then it's probably not practicing law. I mean, that's my very layman's interpretation of it.
Yep.
And that's very good for us. And so I think that, if that precedent stands, then it's pretty clear. The way is pretty well cleared. And I do see, a lot of rules and laws. The USPTO has a thing called the OED. It's an enforcement organization. And I look at some of the things that they are intended to do. And the only reason I can see it exist is to sort of protect the legal guild. And it's not really good for the market. It's not good for the consumer. It's not good for any of these people. And so, and technology, it's not going to replace lawyers, but it's going to have a huge impact. I mean, jobs, and not, as you guys know, not just in the legal space, but jobs in general in legal are going to be severely impacted by this. And, I think getting out in front of it and really understanding it and figuring out how to deploy it in your practice is going to give you the advantage.
Boom. So not to push this into, dystopia here, but we've heard people and we've seen it on social media and stuff too, who say, and I don't want to be like, we've heard people, but we've had examples shown to us of an AI writes the terms and conditions and another AI reviews the terms and conditions. So, and to me, as a non-lawyer, That's kind of frightening. You know, but at the same time, I can see where it's like, look, it's efficiency. This is all boilerplate stuff anyway. Is there some kind of happy medium? Like, is there always going to be a way that lawyers are going to kind of, you know, have a hand in there and saying, wait a minute, this has to work for actual people, and this has to be understandable by people?
Yeah. So absolutely. When I use the term AI, I talk about augmented intelligence. For instance, a huge issue in the industry is an inventor has an idea. Somehow that idea has to get out of his brain and into the brain of somebody who can properly document it. And I cannot see in the next 20 to 30 years how you're going to automate that process. That human communication, the nuances required, et cetera. Now, once you have that idea, I think a ton of, properly described, I think a ton of automation can occur. And that's why I see this being an augmentation as opposed to an automation and a complete replacement.
I love that. That's so cool. I love that. That's it. It really ends up being about the words we choose to describe the future in which we want to live. And so thinking about artificial intelligence is weird because it's like a mannequin telling me what 2 + 2 is. But augmented intelligence is this sort of tango, this technological tango that you need the soft skills, you need the brain. But you've done a wonderful job of connecting those things and being very honest about it. And I think that's one thing that a lot of people are saying, it's my way or the highway, but you're being a little bit more honest and sober about the advice. So we appreciate you spending your time, because you could be automating who knows what else, and patenting who knows what else. But thank you so much for joining us. How can people learn more about you? And if they want to have you come and speak or learn more about your book, how can people learn more about you, Jim?
Yeah, we have all that on our website, is turbopatent.com, and there's a speaking thing there, and I think we download electronically the couple of books that I've written. There's a 30 minute. It's called the 30-minute patent MBA, and it's usually intended for small and medium-sized companies, CEOs, CTOs, those kinds of things, who don't know that much about patenting. So it's a little idiot's guide, if you will, for patenting, and that's there available for free as well. So they can learn there.
5 questions we ask everyone.
5 questions we ask everyone. Here we go. Number 1.
Oh no, you didn't give me these. Okay,
we do that on purpose. You'll see. Trust me. Just we'll work through it together. Number 1. What was the last book you read?
Let's see. The last, the Zero Margin Economy.
Nice.
Are we approaching it, or don't tell us.
but it's headed that way.
Mm-hmm.
Number 2. What is your favorite place?
Favorite place? Let me think. I probably have to say the 18th hole at Pebble Beach.
I've been there, and I agree. Okay, number 3. What sites, blogs, newsletters, or podcasts do you regularly check in with?
So I follow, I'm a Pacific Northwester, so, Bill Gates, and I used to work with some folks that I follow, Brad Feld, those kinds of guys, usually in the area of IP Watchdog. If you're not familiar with that, it's a good thing on IP, but more on general technology trends. It's kind of a fascination.
Solid. All right, number 4. If you were stranded on a desert island and could only pick one condiment to take with you, what would it be?
Ooh, one condiment. Wow. What do I get to put it on? How about sweet pickle? I'm assuming I have hot dogs, so I'm going to put sweet pickle relish on my hot dog.
Nice.
Very wildly optimistic, Jim. I really like this. I'm hanging out with you.
I want that island too, man. Okay, last one. Number 5. After a long day or a long week at work, how do you relax and unwind?
Let's see. Well, I'm now a grandfather for the first time, so it's always fun to see things, especially now at Christmas time, through the eyes of a 1-year-old. So that's probably whether I like it or not, that's my biggest time absorption now outside of work.
Congrats.
Oh, man. Well, congrats. Yeah, that's awesome. That's awesome. You get all the fun stuff without any of the discipline. I'm so
Exactly.
Yeah.
Disappointment.
For show notes, links, and info, go to thelawsonepodcast.com or follow us on Twitter or Facebook. Be sure to leave us a review and rating in iTunes or wherever you find the you listen to. Until next week, stay lawsome.